Credit Suisse, one of the world's biggest private banks, has an extensive history of dealing with crooks, money launderers, and corrupt politicians. But a recent massive leak has exposed the hidden wealth of over 30,000 clients, some involved in torture, drug trafficking, money laundering, corruption, and other serious crimes. The leak points to widespread failures of due diligence by Credit Suisse, despite repeated pledges over decades to weed out dubious clients and illicit funds. In this insider-exclusive Justice in America Network TV special, Justice in America, the Credit Suisse Fraud Story, our news team sits down with Bill Reid and Lisa Tsai, partners at Reid Collins Tsai, to discuss their amazing legal victory of winning a $121 million verdict for their client, Claymore Holdings LLC, against Credit Suisse and related defendants for fraud. The amazing part of this legal battle is that Bill and Lisa won their initial verdict for their client against Credit Suisse for fraud in 2014 for $40 million. In a subsequent bench trial in 2015, deciding additional issues of law and fact, affirmed the finding of fraud and expand that award to nearly $287 million. The bank's repeated attempts to overturn the trial court's judgment issued in 2015 have resulted in multiple appeals, over which Reid Collins and its client ultimately have triumphed after nearly a decade of litigation, trials, and appeals. Then the Texas State Supreme Court remanded the case to the trial court in 2020 solely to reconsider its damages award. In June of 2021, the trial court awarded plaintiffs $121 million. But almost a decade later, Credit Suisse has still not paid the verdict. Court records and major news headlines for the last 22 years show that the Credit Suisse corporate rap sheet has paid over $10 billion in fines and penalties just since 2000 in 49 legal cases, which clearly shows their true corporate character. And every time a team of investigators lifts their financial sector's curtain of secrecy, a web of corruption and nefarious activities is revealed, disproportionately from shady customers and families of dictators, with a smattering of seemingly respectable politicians in democracies caught in the net. Bill and Lisa have earned reputations as unyielding trial lawyers who repeatedly represent clients against big companies and the Goliaths of the world and repeatedly win. They have earned the highest respect from citizens and lawyers alike as some of the best trial lawyers in Texas and across the nation. They have built substantial reputations nationwide by consistently winning cases other law firms have turned down. And their amazing courtroom skills and headline-grabbing success rate continue to provide their clients with the results they need and the results they deserve. This is the Insider Exclusive, live from Austin, Texas. It is my great pleasure to introduce Bill Reid and Lisa Tsai to the show. Welcome to the show.
Good morning.
Thank you.
Tell our audience a little bit about your firm. What type of practice do you do?
I would say we're a plaintiff's trial firm. We bring claims that often would otherwise not get brought against corporate America.
Yeah, and one of the things I noticed is that your firm has sued, I think, 20 of the top 100 big law firms for legal malpractice, right? So you're not a popular guest at Christmas parties with them, right?
Until we're needed.
Let's talk today a little bit about why we're here and the Credit Suisse case, which is an ongoing case that's been going on and on. Give us the facts of the case, please.
Well, the case started almost at the beginning of our law firm, so the case is as old as our firm, just about. The case started really on a hunch by our client, Scott Ellington, who thought that Credit Suisse had some hand in a busted loan on a big real estate deal in Las Vegas called Lake Las Vegas. He had no proof of that, just really suspicion. All he knew is that the loan, which was $540 million made on the property, was not supported by the value of the collateral underlying the loan. In fact, it was ultimately sold, I think, in 2011 for $17 million. Yet, the appraisal supporting the loan stated that the value of the collateral was, as I recall, $511 to $891 million. So he began to ask, and we began to ask, how could $500 million of collateral be worth so little? And that caused us then to focus on the appraisers.
Yes, and I think initially an outside observer might say, well, you're looking at the year of 2007. What happened afterwards? We all know, the markets fall off the cliff and real estate takes a nosedive. And so it wasn't immediately obvious to everyone that there was, in fact, malfeasance, that there were misdeeds at the root or the cause of these large losses. And so that's what our team came in to do, frankly, against the weight of many others, including other lawyers and other teams who said, no, this doesn't look like there's anything here. After dozens, hundreds, thousands of hours of man work and investigation in connection with this deal alongside our client, we found out that, in fact, the cause was not real estate market losses. This was a result of misdeeds.
Take us through the litigation process here when you first filed the lawsuit and what has ensued after that and what you were up against, the obstacles, the hurdles that you have run into.
Lisa called it misdeeds. Let's just call a spade a spade. We're talking about fraud. And the investment bankers at Credit Suisse were found to have committed fraud in this case under the facts. And so we didn't start with a case against Credit Suisse because we didn't have one. We had no proof of one. Because you have to realize that a loan syndicate in the real world only receives the final appraisal. They don't see the whole process that leads to the final appraisal. And that's really where our job was. So we began with a case against C. Richard Ellis, the appraiser. Credit Suisse was not even part of the original suit. In that suit, we sought discovery to understand the workings of the investment bankers with the appraisers. And as I recall, they fought you pretty hard.
Yeah, one thing I'd say, just to throw in kind of where we were personally too, if you think about it, Bill and I, who worked together for some time already, we had just started this firm around Thanksgiving of 2009. We were called in to do this a few months later, so call it 2010. And I had just had my first child in 2009. And we are sitting here now, obviously, a decade later, on our second appeal on this issue. But we're going to get justice here. We already won this fight. But to give you a sense for, it has taken years of commitment and work to really reveal the fraud. And Bill's correct, it's absolutely fraud. A jury and a judge both found that Credit Suisse committed fraud.
Well, let's go back. In the C.B. Richard Ellis case, we sought discovery to understand what communications and interaction occurred between the investment bankers and the appraiser.
And let me interject something here with this question. When you say you sought discovery, what are the roadblocks that a institution like Credit Suisse, who has all the money in the world, right, who can hire the best law firms, what are the roadblocks that you encounter to get that discovery?
Well, Credit Suisse argued in the appraiser case, hey, we're not the appraiser. Your beef is with them. What relevance does anything we do have with your case against the appraiser? And we were like, everything. You hired the appraiser. It was your job to deliver the appraisal to the lenders. You were integral to this process, and we need to understand your role. Of course, we had an underlying motive. Our ulterior motive was to determine, could we prove that Credit Suisse played a hand in what was obviously a fraudulent appraisal? And as it turns out, the documents revealed that it was really Credit Suisse who mandated and dictated all of the appraisal results, and along the way, pushed that value way higher than the initial value, and a set of facts that the jury found quite compelling. And the Texas Supreme Court, which never affirmed a fraud finding by a jury, affirmed one.
And that's right. I think the key to being able to unveil what actually happened was, in fact, that case against CBRE, getting access to key documents. And that's I mean, generally in these complex cases, always the situation, right? It's why defendants will fight you tooth and nail not to give over their emails, because generally speaking, the goods are there, and they were here in this case as well. We found that, in fact, over the course of this one weekend in April, as they were preparing this appraisal to try to now sell this, it was a refinancing loan transaction to the marketplace, that a group of Credit Suisse bankers, along with the CBRE appraiser, conspired, essentially, to pump up those values in that appraisal. That's the secret sauce that nobody, no investor, no one would have ever seen, frankly, if it weren't for the system we're in here, where you can go into court, you can make out your claim, and you can get access to documents that will actually show what really happened.
Is there a point in time when you're continually going to court because they're refusing to turn over the documents where a judge might say, hey, you know, I'm sick and tired of the defendant not cooperating here, and I am going to, what, fine them?
It's called a motion to compel. We did have to file, as I recall, a motion to compel. And the judge, Judge Raji in this case, she said, no, these documents are relevant. You need to turn them over. And as I recall, Credit Suisse took the initial position, fine, we'll give you the documents related to the refinancing, but we will not give you the documents relating to the original 2004 loan. That is also irrelevant. We had to fight over that issue too. The court said, your involvement in the original loan is equally relevant. Turn those over too. And we found a treasure trove of lies and misdeeds in there as well. These investment bankers absolutely dictated the value, the appraisal process. They came up with their own methodology for the original loan. They were actively involved throughout the process of the supposedly independent appraisal.
Now, bring us up to date. What is the status of this case going through the appellate courts and process? Right now, you have a verdict of, what, $121 million?
You got to understand, this is a Swiss bank. They get charged with wrongdoing frequently. They have a fortitude that many other litigants lack, right? So the Texas Supreme Court did something it rarely does and affirmed a jury verdict of fraud, but remanded the case to recalculate damages because it felt that the remedy issued by the trial court was inappropriate. So we went back to the trial court, who issued a second judgment, in this case $121 million, and the parties are fighting over whether that judgment, they're still contending it should be zero based on a bunch of arguments, and we're simply saying the trial court did the right thing.
And what do you project in having this finally come to the end?
It's difficult to determine because our Texas Supreme Court is a court of discretionary jurisdiction. So even if we win this intermediate appeal, there can still be another round like there was in the first round of appeals, and that would add probably 18 to 24 months to this process.
Wow. Just over and over and over. And by the way, this is a case that a lot of law firms would never handle, right?
I think other firms would have taken the Credit Suisse case after the work that we did in CBRE revealed the evidence that we ultimately used to prove fraud. But I think very few people would have approached the case in the methodical way that we did, gotten the appraisal case done, and the proof that we had a fraud case against Credit Suisse.
In these type of fraud cases, what do you have to prove in court?
New York law requires proof of fraud by clear and convincing evidence, which is a much higher burden of proof than preponderance of the evidence, the ordinary standard in civil litigation. We had to prove that the Credit Suisse investment bankers knowingly and intentionally acted to inflate the value of the appraisal with the intent that it would be relied upon by our clients, who put in $250 million initially and tens of millions of dollars more subsequently.
So that our audience clearly understands what is the motivation of a bank giving such a excessive loan? What do they get out of it?
Very good question, and the answer is their fee. So on a $540 million loan, the investment bank gets 2%, in this case $10.8 million. All the investment bankers, all any banker cares about is their year-end bonus. So they were motivated to put this deal through to make a $10 million fee, so at the end of the year, they could put money in their own pockets. So people often ask the question, why would a bank do this? Banks have no incentive to commit fraud. What's $10 million to a multi-billion-dollar bank? And that's the wrong focus. The focus is not on the institution, but the individuals who act on its behalf. And they are highly motivated to make their own bonuses. They don't care what happens years later to the bank. They're probably going to be gone.
Are those same bankers still there?
Some of them are, believe it or not. Some of them are. And it's the most remarkable thing, but Lisa and I, we were in the courtroom, and his name was David Miller, testifies on the witness stand, and one of the damning pieces of evidence we had against him was his admission that there were problems with the appraisal. He openly admitted that. And basically, that's why Credit Suisse, when the loan closed, they couldn't sell all of it, so they kept the $34 million piece, and they put a loss offset out of their $10 million fee to cover any declines in value of their $34 million position on the day the deal closed. And he admitted they did that because of problems with the appraisal. So he testifies to that and to a host of other kind of damaging things. When he walked off the witness stand, he walked over to our table, out of the presence of the jury, shook my hand and said, "Good luck," with a smug look on his face. He did not care what the outcome was.
You know, we've done some other cases that are totally different, Child Protection Services, Department of Family Services, and I once asked a lawyer who represents people in these cases, I said, do you encounter, because there's a lot of, the government employees that just don't care about the outcome or the fact that they may have to end up paying $5 or $10 million to the victimized families, right? I said, do you encounter these same individuals in time after time when you're suing the same CPS or the same Department of Family Services? He says, no. And I said, did they get fired? No, they got promoted. And I'm thinking in your business, that business too, right?
The guy I'm talking about lives in Westport, Connecticut. At one point anyway, had a helicopter landing pad outside his house, was making tens of millions of dollars a year in salary, was the head of global fixed income at Credit Suisse. He doesn't care.
So last question, you are an unusual firm. The more I do research about your firm, thankful that you do what you do. I mean, you take on these complex business cases that a lot of law firms won't do because it requires a lot of detective work, right? How do you determine what cases you're going to handle? What's the criteria?
We have a whole process, but I would say in response to your question, here's my observation. I was a federal prosecutor. I think I've told you this before. And at the end of a case, someone would go to jail. I got no personal reward out of that. In fact, it was depressing. And why we do what we do is because these people, like the investment bankers in this case, understand one and only one language. That is the language of money. So when you make them pay money, you absolutely are taking a step towards deterring their future wrongful conduct. Now, is it a perfect solution? No, because in this case, the bankers who committed the fraud already got their bonus. They're not going to have to pay that back. They're already gone in most cases. So the answer to your question really is, what is the method by which we can penalize these people when the government is, I think there were only 2 or 3 or 4 prosecutions out of the entire financial crisis. This case stands as one of the few examples of a pre-financial crisis set of facts going to a jury, and you see the outcome. And now you begin to understand, why did these banks pay billions of dollars in settlements after the financial crisis? Because when juries see this sort of conduct, they hold people accountable, and banks know it. And I think it's changed banking after the financial crisis. I think they're a little more careful.
Well, let's hope so. And congratulations on the outcome of this case and the continuing outcome of this case. Thank you.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.